The treaty defines non-territorial seas to be the common heritage of mankind. In other words, non-territorial seas are a global common, which the treaty places under the jurisdiction of the United Nations. This is a horrible precedent. Will the next treaty place the atmosphere under the jurisdiction of the United Nations? The Commission on Global Governance defines the global commons to be the atmosphere, outer space, the oceans beyond national jurisdiction, and the related environment and life support systems that contribute to the support of human life. Each nation that ratifies the LOST may have one representative in the Assembly, which is also the International Seabed Authority. The authority elects a 36-member council which serves as the executive committee of the authority. The council chooses an economic planning commission and a legal technical commission, both of which have 15 members. The council also chooses a secretary general who prepares the budget for the enterprise. The enterprise does the work of the treaty. The authority selects a 15-member board of directors who are paid a salary for their work, and the authority selects a director general who is the chief executive officer of the enterprise. The President says that ratification will give us a seat at the table when the rights that are vital to our interests are debated and interpreted. A seat at this table would cost not only 22% of the operating budget, but would also require the surrender of rights we already possess to the control of the International Seabed Authority. As in previous treaty debates, proponents will claim that the treaty provides the U.S. with an effective veto. It does not. Only certain actions of sub-councils may be blocked, when opposed by 3 of the 4 largest member nations on the sub-council. On the all-important Finance Committee, this blocking capability ends when the enterprise is no longer dependent upon member assessments. LOST requires the exercise of U.S. sovereignty be subjected to the UN Treaty. Regardless of the denials by Senator Lugar and others, the clear language of Article 2, Paragraph 3, subjects U.S. sovereignty over territorial seas to this UN treaty. The LOST offers no benefit not already possessed by the United States. Navigation rights and privileges are covered by other treaties that already exist. The LOST adds nothing. The LOST gives a UN body control over 70% of the Earth's surface, defined to be a global common. This is a horrible precedent, because the global commons, in the UN mind, includes the sea, as well as the seabed, the atmosphere and outer space, and the related environment that supports human life. The LOST gives a UN body the power to tax in the form of application fees and royalties. This is another horrible precedent, because there is nothing to stop the International Seabed Authority from taxing the use of the seas above the seabed, or the air above the sea. The Law of the Sea Treaty affirms the socialist philosophy of government control of the sources of production by creating the enterprise, which has the exclusive power to exploit the seabed, as well as the power to grant or deny capitalist entities the privilege of paying a fee and royalties to compete with the UN-owned operation. Reject the Law of the Sea Treaty. President Reagan rejected it in 1982. The Senate refused to consider it between 1994 and 2000. The Senate refused to consider it again in 2004. This treaty should be killed and buried beneath the deepest ocean, never to rise again.